Yes.
If I may not show these two, it begins with the 1948 Act. And this, Your Lordship will find in volume 4, page 891. This was not a rather short statute. Please mind. And this really not focused on conferring rule-making power.
Volume 4, sample 4.
I should save it on the iPad.
Page 891.
Your Lordship will recall, this is under the 35, so where oil fields were still a part. That adds another nuance to this, which I will deal with separately. It is hereby declared that it is expedient in the public interest that central government should take under its control the regulation of mines and the development of minerals. That's how they understood the two expressions. You don't regulate minerals. That's how the English was. Very carefully worded. Minerals are not defined in the widest possible word. It says minerals include natural gas and petroleum. Mining lease, Your Lordship may see the definition in D, means a lease granted for the purpose of searching, winning, working, getting, making merchantable, carrying away or disposing of minerals. So if Your Lordship is not pleased to notice the width of the declaration, it's very wide. And that's why, my lord, the three cases which have not been shown so far, which directly dealt with these. Took the view that there's almost denudation because declaration was very wide. This act, my lord, was terse. It only provided in section 4 that no mining lease shall be granted after the commencement of this act, otherwise than in accordance with the rules made under the act, and anything granted is void. Then 5 was, my lord, the rule-making power of the central government. Your Lordship may see. The one is central government may by notification in the official gazette make rules for regulating the grant of mining leases or for prohibiting the grant of leases in respect of any mineral. And then, my lord, in 2, what is important, in D, fixing the maximum and minimum rent payable by a lessee, whether the mine is worked or not. That's dead rent. Then, my lord, 6, power to make rules with respects to mineral development, which again, 1 is the general power. Central government may by notification make rules for the conservation and development of minerals. And then it says in particular, what is important is, my lord, I mean, I'm not troubling your lordship reading the details, my lord. All the dimensions are covered. The technical bits, the working bits. And I says, and I'll read it a little slowly, the levy and collection of royalties, fees, or taxes in respect of minerals mined, quarried, excavated, or collected. Please mark the word, if your lordship don't mind, levy. So your lordship asked a question, my lord, I didn't want to interrupt when your lordship asked that question about if the state can't tax, can the union tax? And the answer given by this court is yes. And that's how all the validation acts were made. But that's a separate conundrum. We'll deal with it separately.
But this act is a pre-constitution act,
No, no. When
1948
after
act.
India Cement struck down, Parliament came with a validating legislation. That was challenged, saying, where does Parliament have the power? Your lordship said, well, if the state doesn't have the power, then it goes to Parliament.
That's levy.
I call that not the Kannadasam conundrum. Your lordship will have to consider it separately. And it has to be under 97. It doesn't say under what. But that's a separate conundrum. Let me not digress.
This particular provision that you have read out just now,
Milo.
subclause I, they have used different expressions. Levy, they don't simply speak of royalty. They talk about levy of royalty, levy of fee, levy of taxes. So these are all used differently
My lord,
in this
your lordship will see the rules.
subclause I.
Your lordship may just see the rules. Because what's our case? Let me tell my lord why I am troubling your lordship showing all this. Once the 48 Act came into place, the exactions were all treated on par. And in fact, in the parliamentary debates relating to the 57 Act, one of the members said, the royalties, which is the tax on minerals, has been now also taken away by Parliament and you're imposing it. Under 9. There was no 9 in the old Act. That's important. Your lordship notices. Now we have 9 under the new Act. There was no 9.
That again speaks of royalty only.
Yes. What is the character of that royalty? We say it's an exaction because one has to, let me not get ahead of myself. I have to show all that. But this is how these were all considered as royalty, fees, taxes in respect of mineral mine. And the word used is levy. Levy is normally a word which one uses for an exaction, not contractual payments. But there was nothing, our submission is going to be, there was nothing contractual left here. It was all statutory. And now we have gone to the extent, again, I'm getting ahead of myself, but I want to show all this. We have gone to the extent, if you don't pay royalty, you can be sent to jail. It's a criminal offense not to pay royalty. If a tenant doesn't pay a landlord, you can evict him, you can cancel his lease, you can throw him out, you can't send him to jail. So these are all now statutory exactions.
Does it have anything to do with the word royalty, royal dicta?
Well, today, what has happened
So
is
jail.
totally. It has. I'm so sorry.
It originated in Britain with that.
Okay.
What was given to the crown?
It is what the crown took as its share. And they took everything as their share. That's why originally, I'll show Megari is a very interesting passage. Except gold and silver. Everything belonged because those are the royal minerals. If you wanted to hunt in the forest, you had to pay royalty. If you took any of the royal animals, to fell a tree, some trees were marked. But it's a very, it started that way. It always started because otherwise, what Malad in English law is called the estate in fee simple, absolute ownership. But everybody was a tenant of the crown. There was no, till now we will not have freeholds. But so, may I quickly show this act? I continue. Yes. So, Malad, this is one point which I wanted to make. And yes, I acknowledge the word levy has, it's again not a term of art. Levy can mean charge, levy can mean collection, levy can mean fixing the point of recovery, etc. But what is important is the assessment, everything. But Malad, the important point is the phrase. I'm not putting too much emphasis, but showing how the legislation was drawn. Levy and collection of royalties, fees, and taxes. There's a lot more fleshing out of this in the rules. Section 7, I'll only read the heading. We don't need to get into any details. The power to make rules for modification of existing leases. But if there's anything your lordship want me to show in particular, please. I'm trying to pace so that I finish by tomorrow, Malad. But it's not with the idea to skip anything. And then, Malad,
Yes, yes.
Section 10, which was noticed in one of the cases, that all rules had to go before the central legislature. So basically, even if later on the state has made rules, they say you're making it under a union law, you're making it as a delegate. You're not making it in your entry 23 capacity. This is Malad, the 48 Act. Now it's Malad, the mineral concession rules.
Mr. Salve, you might read the penalties part, that's section 9, I think.
Yes, Malad. Section 9, Malad. Any rule made under provision of the Act may provide for contravention shall be punishable with imprisonment, which may extend to 6 months or both, which may extend to 1,000 rupees. Now, Malad, this became a lot more sharper in the 57 Act. In fact, I'm going to read the statement of objects only. The Lordship said a lot of it was, 48 Act was virtually a skeleton law saying everything will be done by the rules. But in 57, the idea was they said, no, we must have a lot more in the Act and lot less in the rules. So it has gone, and one of these cases have now over the decades come to this court. And your lordships have clarified. If you have a lease and don't pay, you get hit by the Act. If you don't have a lease, like in the sand mining cases, then the IPC will apply. Under this Act, there was a general delegation of the power to impose penalty under Section 9. And interestingly, curiously, Section 13, Act is binding on the Crown. Then, we come to the rules, which are the mineral concession rules. And these are in volume 4I.
Page 28.
Lordships have volume 4I.
Page 28, right?
And Malad, I've got a scanned copy of the book, whatever is convenient to see, Malad. That I copy the comparative pages.
Volume.
We have rules,
Copy as well, but
Yeah.
you can go to the scan copy.
whichever is convenient. Scanned copy, page 3 first. Definition of mining lease. Mining lease means a lease to mine, quarry, bore, dig, search for, win, work, and carry away minerals specified. And minor minerals are defined. I won't trouble your lordship with the detail. And rule 4 is important. The rule shall not apply to minor minerals, the extraction of which shall be regulated by such rules as the state government may prescribe. A lot more flexibility at that time. So the rule-making power upon the state came from Rule 4 of the central rules. Then, my lord, there used to be a concept of a certificate of approval, which was later dropped, that nobody could get a mine unless he has a certificate of approval. I won't trouble your lordship with that. Come straight to Rule 14, which is at page 5. Now, what is important is, my lord, all these apply only to government-owned minerals. That your lordship get from the heading of chapter Roman 3, the heading which your lordship will find at page 5. Yes, it is fine. I see, it's page 6. Line 5. Pagination has gone. Okay. And what is the, I want to show 14 straight away. An application for a prospecting license shall, in the case of land in which the minerals belong to the government, be made to the state government concerned through such officer, etc., etc. So, my lord, it is under the union rules that you went to the state. Then 17, and one important feature, I'll just mention it and then I'll show. The whole thing had become statutory, there's nothing contractual. The state used to make orders of grant or refuse orders of grant. And if they did, there was a quote-unquote revision before the central government. And then, of course, it used to come in judicial review to the courts under 226. So it became a whole statutory mechanism, right from prospecting license, grant of leases. You passed a statutory order, you granted a lease. Somebody who was not happy went to the union government, and the union government decided it in revision. I'll show all those provisions. Rule 17 says, the state government may grant or refuse a license. Subject to the provisions of Rule 13, the state government may grant or refuse a license. In case of refusal, intimation shall be given to the applicant in writing, etc., etc., on the payment of a fees. All this, my lord, shows the character. There's no contractual this here. You're not discussing anything with the state. Then, my lord, Rule 18, I don't propose to read it, just the heading is enough. Priority. So there was a statutory priority on how this would be granted. And there used to be a register of prospecting licenses under 20. And 23 is relevant. Every prospecting license shall include the following conditions. This is the first. The licensee shall pay prospecting fee as may be fixed by the state government, not less than 2 annas and not more than 1 rupee per acre of land covered by the license. It's clearly an exaction. And small 2 was in the case of minerals other than gold, silver, precious stones, or mica, the license shall not confer upon the licensee a right to win or carry away the minerals. The rest is all matter of detail. So even for prospecting license, you have to pay a fee. And today it may seem very little, but at that time it was not so little. In 48, 1 rupee an acre. If 1,000, 2,000 acres are granted 2,000 rupees, it's a significant amount of money then. Then 24 at page 11, right to mining lease. On or before determination of his license, a licensee shall have a right to a mining lease or leases over the whole or part of the area covered by the license in accordance with the rules. And then, my lord, the next chapter again is grant of mining lease in respect of land in which the minerals belong to the government. My lord, 26, I'll just read the headings. This was about the certificates of approval, etc., as a condition of eligibility. Rule 27 was the application for a mining lease. The application had again a statutory levy of fees in Rule 28. And then they inserted 28A, which your lordship will find at 13. It said when a mining lease is granted, the formal lease shall be executed within 6 months. So the grant was by an order. So there used to be an order sanctioning the lease, and there used to be, to borrow the words of the rule, a formal lease executed within 6 months. Rule 35 at page 14, with the area of the mining lease, not troubling your lordship with the detail. Rule 40 is relevant, which is at page 15. The period for which a mining lease may be granted shall be 30 years, and for so and so. And for 20 years, other minerals shall ask for a shorter period. Or the lease shall be renewable at the option for 1 or 2 periods not exceeding the duration of the lease in the case of iron ore or bauxite for the manufacture of aluminium, and 1 period not exceeding the duration in the case of other minerals. When the renewal is granted, the surface royalty and surface rent charge shall be at the rates in force at the time of the renewal. Head rent shall be charged at the rate a state government may fix within the time limit specified in the 3rd schedule in force. Then, my lord, Rule 41, that's important, directly relevant for us. Every mining lease shall include the following conditions. 1, the lessee shall pay royalty on minerals, please mark the words, my lord, dispatched from the leased area in accordance with Schedule 1 to the rules. So this was mandatory. The lease shall have a condition that you will pay royalty on the minerals dispatched. And this has to be in accordance with the schedule. Provided further in the case of lease executed after coming into force, you should not be required to pay during the currency, etc., etc. And small 2 is if any mineral not specified in the lease is discovered in the leased area, he shall not win or dispose mineral without obtaining a lease. If he fails to apply within 12 months from the discovery, government may give the lease in respect of any mineral to any other person. The lessee shall also pay for every year, except the first year of the lease, yearly dead rent within the limits specified in the 3rd schedule, to the rules as may be fixed by the state government in the lease. And if the lease permits the working of more than one mineral, the state government may charge separate rent in respect of each mineral, provided that the lease shall be liable, lessee shall be liable to pay dead rent or royalty in respect of each mineral which is higher. Small 4 is important because when I deal with Murthy's case, This will have some bearing. The lessee shall also pay for the surface area used by him for the purpose of the mine's surface rent at a rate not exceeding the land revenue, and the cess is assessable on the land as may be specified by the state government in the lease. Please mark the words, madam. Rate not exceeding the land revenue, and then it is added, and cess is assessable on the land. So that becomes a condition of the lease. Rest are not all technical conditions. I won't trouble your lordship with the details. Rule 42 is the rights of the lessee, the only technical things, working mines, sinking pits, etc., etc. And Malad, there was a separate chapter, chapter 5.
Anything with regard to 47, Mr. Sal? Just have a look at it.
Rule 47.
Yes. Says a mining lease granted by a private person.
Yes, I was going to read that whole chapter. Malad.
Okay,
It's very important. The provision of the chapter shall apply to mineral concessions granted by private persons. Then, Malad, very interestingly, same conditions are put. You have to have a certificate of approval. So you can't grant it to whomever you like. The conditions of prospecting license are specified. The conditions of mining lease are specified. And 47
Yes.
is part of that chapter. The mining lease granted by a private person shall be subject to the following conditions. Except leases in respect of coal, iron ore, bauxite from the manufacture of aluminum, for which period the lease shall be of 30 years, all leases shall be for a period not exceeding 20 years. They shall be renewable at the option of the lessee for one term, etc. Then 2 is not relevant. That's one interest, Indian interest. Please turn to small 4. The provisions of 1, 2, 3, 4, 5, 7, 8, 9, 10, 11, and 15 of subrule I of Rule 41 shall apply to such lease.
Royalties also.
So that takes us back, Malad, to page, I'm so sorry, page 16, subrule I, the very first one is shall pay royalty. So statutorily, that's imposed even on when a private person is granted. With such modification that for the state government, the word lesser will be substituted. The lessee may determine. I'm so sorry. And 51 is important. No person in granting or transferring or obtaining a prospecting license or a mining lease or any right, title, or interest in a license or lease shall charge any premium in addition to or in lieu of prospecting fee, surface rent, dead rent, and royalty specified in the license or lease proportionate to such right. I want to state the point so that I want to my lord, flag one point here. I don't want to get into it because that's a separate part, but it's very important. Is the state's right to tax the mineral rights granted by a private lease? Question mark. It is possible to argue that exaction, that is not an exaction of the kind which would denude the power of the state. Because the law treats as two separate classes, land vesting in the government and land other than the government. They could have made one common rule saying the royalty shall not execute Schedule 1. It's the same schedule. It's the same rate.
Who grants the mining lease makes a difference. If it is by a private person, then the royalty goes to the
Private person.
private person.
And is that an exaction by the state? The answer is possibly no. And
Does
that
the
be taxed?
does the nature change merely because the land vests in the state government?
It would. It would. Nature of what? Well, let me be
The
very
nature
clear.
of the royalty is the same.
No, I'm sorry.
Whether the quantum is obviously the same,
Well,
but the
let me-
nature of the royalty, whether the royalty is demanded by the state government or by a private person who owns the land, who owns the mineral rights, is essentially the same.
But the point which, that's why the thing is, we didn't open this case. My learned friend, that's why I said 90% of what he argued was non-contentious. The expression royalty is a tax is a very shorthand expression. The real point is something very different. How we developed it to saying royalty is an exaction by the state, which is regulated, and Section 9 displaces any further exactions, which takes to the next step about royalty therefore being akin to a tax, and which then becomes a shorthand expression, royalty is a tax. And that shorthand expression then is treated like a proposition of law, saying royalty is a tax, and then you say, hold on a minute, that's very counterintuitive to say royalty is a tax. What is the real legal principle on which we say that Section 9, and there is a serious change made in the new act, which I will come to. Why do we say Section 9 displaces any possible tax on mineral rights? Is because the limitation contained in entry 50, which says subject to a law on mineral development. The exaction by a state is contained in 9. That it is an exaction is enough for me. I may be right or may be wrong, but what we are going to show is that if I am right that this is an exaction by the state, and then your lordship will have to see whether an exaction by the state pegged at a particular figure, whether that can be added to by having a de facto tax on royalty and trying to say, but this is only a measure. That's the real point. Well, this tax, royalty is a tax, this shorthand expression is created certain conceptual problems. And it's very counterintuitive to say royalty is a tax. I'm only showing it is completely statutory. There's no contractual element left in any of this.
So you are also proceeding on the footing that royalty is not a tax.
Well, not in its classic sense, it's not. It's very counterintuitive to say royalty is a tax. The real point which your lordships have to consider is not whether royalty is a tax or not a tax. In fact, your lordships see the questions which have been framed, and the way they have been framed, is what are the real limitations in entry 50? Either we are right or we are wrong. That's the real point. Because this akin to a tax became, oh, therefore a tax and therefore royalty is a tax. This is, my lord, sometimes shorthand expressions are treated like propositions of law and then you run into conceptual problems.
Mr. Salve, in the judgments that are under discussion in the present proceeding, did they have an idea to interpret in the constitutional sense what is tax? Because if you go into the definition section of taxation, 366,
28.
28. In those India Cement and Kesoram, they did not have that idea in their mind.
But that's my point. In that sense, nobody said royalty is a tax under 366/28. And that may be taking a point one step too far and one unnecessary step for me. As I started by saying, my case is based on what is the limitation in entry 50. I mean, whether I'm right or whether I'm wrong is another matter. But what is the limitation in entry 50? If there is a complete code of how much a state can receive from land which vests in the state, is that not what occupies the field, and is that not what removes from the state's taxing power the power to tax royalty? Because then you run coach and four through this. The union says and your lordship will see why. They said states are overcharging royalty at the cost of other states. Show all that in the material. So they said we must fix it. Now you fix the rate of royalty at 50 rupees per ton. And then you say, yes, royalty 50 rupees per ton. And 300% of the royalty is tax on mineral rights. Then what's the use of fixing 50 rupees? And then you pass it off saying, oh, but this is only a measure, this is a tax on land, this is a tax on mineral rights, and so on and so on.
See, there could be various types of exactions on mineral rights.
Yes.
If that is considered to be the imposts or taxes or whatever you may call exactions as a genus, then royalty is only a species.
I'm deeply obliged, and that
It
is
is
why.
only one aspect.
I'm so sorry.
Sorry.
Your ladyship is absolutely right. In fact, the problem arises when we start generalizing. We have to see each law and see where it sits. This side of the line or that side of the line. It's very difficult in these matters to try and enunciate some sort of a one mantra for all problems. It doesn't fit that way. There is a law which my learned friend was defending, which says 1 rupee 50 paisa for any land use for any purpose. Maybe it passes muster. So it may not, this attention to detail, and this is very important because on the one hand, we are balancing national resources, competing equalities. And on the other hand, you're dealing with a very vital power, a power of tax conferred on the state. So we have to be very careful, and the devil lies in the detail in this. You have to look at exactly what is it that we are talking about.
So if one species of exaction is taken away from entry 50, other species of exactions are available to the state.
May remain.
It will remain, but royalty cannot substitute for all species of exactions.
My respectful submission is that is precisely what this court will have to delineate. What is it that gets taken away, and see the laws which we are concerned. Do they cross the line or do they stay within the line? And I would not submit any generalized statements is where we get into difficulties, because this is a very sensitive area of constitutional law. It's a complex area. And either way, a generalized statement saying, oh, any kind of tax can pass muster is as flawed as saying no tax can pass muster. But I'm getting ahead of myself. If I show all these rules,
Each act has to be a C.
so my lord, the important thing which I wanted to show is that the rules right from 48 had two packages. They did not treat the state as yet another owner of land. And in fact, my lord, Rule 47 mirrored Rule 41. They didn't have one common rule applicable to both. Now, what's the significance of that? I will develop later. The state as the owner of minerals, my lord, the genesis of that goes back into our land reform laws. And the later and the currently the national policy 2019 and all, make it more and more clear. We are now talking in terms of intergenerational equity. We are talking of state as owning mineral resources and owning it for public good, etc., etc. No longer, my lord, the concept of the crown. The Raja owned everything. And it's with his permission that you were taking his wealth, so you gave him a part of the produce. But that concept has died. What did you give the king? Everything belonged to him. So you take something, you share with him. Land revenue was that, you shared produce. Those colonial concepts, my lord, have perished post our constitution in 50. That's the point which I'm trying to make. So we have to accommodate that. And that is why right from 48, the state as the owner of mineral was treated separately from a private owner. They could just have put everything under 41. One more rule and I'm done with this one. Page 22. There's a complete different track running for state leases. Rule 57. Any person aggrieved by an order of a state government refusing to grant a certificate of approval, prospecting license or mining lease, refusing to renew a certificate of approval, refusing to renew a prospecting license or cancelling prospecting license, refusing to permit transfer, etc., etc., may within 2 months of the order apply to the central government for reviewing the same. This was not called the revision. As young lawyers, we all benefited out of this provision considerably. To Shastri Bhavan to argue these revisions.
Is it the same as the Mines Tribunal?
Came later, yes. Huh?
Popularly called the Mines Tribunal, though.
Yes. Earlier, it used to be a civil servant, a joint secretary or somebody used to sit in here. Even now.
Government revision to government.
Schedule 1, which imposes, or rather which sets out the rates of royalty, is at page 25. Gold 5%, mica so and so, gold, silver, chromite, oil, shale. Only to show that this was, at that time, it was not ad valorem. It was what, borrowing the excise duty language. Except coal was 5% for statutory price. It was what we in excise law we used to call the specific rates. So much per quantity. And the unit used at that time now has gone into disuse, MOND. This is the rule of concession rules of 49. I think it may be a better use of time if I show your lordships the 57 Act, the 57 rules, and then go to the judgments.
Right.
Have interpreted.
Fair enough.
Now, my lord, the 57 Act is the original parliament.
Page 92, volume 4I.
My lord, there have been, the problem with the textbooks now is there was very serious, very substantial changes made in 2015. So I wanted my lord to see the act as it first came, and that's the this act your lordship will find
Page 92,
at page 92 of volume
4I.
4I. No, my God. Objects and reasons. It's not in this. If your lordships have, it's in the volume 4 statutes.
Yeah,
57 Act. I may have to ask your lordship first to turn to volume 4, page 910. The statement of objects and reasons. That's important.
Same volume? Page 910.
The differentiation made between petroleum and other minerals on item 53 and 54 of the union list has rendered separate enactment necessary. The present bill deals only with minerals other than petroleum
Volume
at
4,
present.
page
both are
910.
1-4.
914, I'm so sorry, 914. It begins at 910.
Yes.
The statement of objects and reasons is set out at page 914. The differentiation made between petroleum and other minerals of 53 and 54 of the union list has rendered separate enactments of the two necessary. The present bill deals only with minerals other than petroleum. At present, both are dealt with under the Mines and Minerals Regulation Development Act. Opportunity has been taken of putting forward this legislation to make some necessary changes in the provision of the existing act dictated by experience. These changes refer to the prescription of maximum 50 square miles, then my lord, second, renewal. Third is authorization of government to undertake prospecting and mining after prior consultation, promulgation of rules. 5 is important. The recovery of royalty, dead rent, and other sums due to the government in the same manner as arrears of land revenue. And incidentally, my lord, when your lordship had seen the section as to why is this here, my learned friend said, oh no, this is only for some past dues of 48 Act. That's simply not right. It is for dues under this law, because it says under this act. And the old rules continued only to the extent they were compatible with this act. And my lord, it goes on further. A number of provisions hitherto dealt with under the rule-making powers of the central government have been transferred to the act in order to restrict the scope of subsidiary legislation. These provisions are, and my lord, we are concerned with small 3. The power to prescribe rates of royalty for various minerals in clause 9 and schedule Roman 2. There was an amendment made in 58, and my lord, some of the concerns flagged need to be seen. If your lordship sees para 2 of the next one, your lordship has statement of objects and reasoning of the amending Act 58. The Mines and Minerals 57, which replaces the Act of 48, specifically extends the rate of royalty prescribed in the second schedule to mining leases granted in respect of coal, and also makes it obligatory for other terms and conditions of the leases to be brought in conformity with the provisions of 13 to 18. it is considered that these changes will have numerous undesirable consequences. The area covered by the mining leases are principally in West Bengal and Bihar, and they account for as much as 80% of the total coal production. The royalties paid on coal vary over a wide range, but are generally much below the rate per ton prescribed in the schedule. A sudden and uniform increase in royalties is likely to have unsettling effect on the industry and may retard the program of coal production under the second 5-year plan. The same adverse effect would be felt by sudden modification. The object is to exempt mining leases granted so and so. I wanted to show this because one of the impact of royalty on development. I joined at the hip, if one may use that expression. And that's flagged in this statement of objection reasons. That if you suddenly increase royalty, it has a direct impact. And the concern, Malad, because, for example, coal was found mostly in West Bengal and Bihar. And if you increase the rates of royalty, it impacts other states. I will only show, Malad, the 72 Act for the present, and then, Malad, move to the statute. Statement of objects and reasons for the 72 Act. Over 14 years have elapsed since the Mines and Mineral Regulation and Development Act came into force. In course of these years, large strides have been made in the development of mines and minerals, the production task before the nation. In the fields of steel, non-ferrous metals, fertilizer, chemicals, power generation call for measures of systematic and massive utilization of the natural resources of the country. The Mineral Advisory Board has from time to time reviewed the working of Mines and Mineral Regulation Development Act and made recommendations for amending some of the existing provisions of the introduction of these new provisions. The recommendations cover the following principal points. And small Roman 2 is the imposition of specific obligation of holding of mining leases in respect of payment of royalty for minerals removed by their agent sublessees, provision for statutory basis for calculation of dead rent, etc., etc. And small Roman 10 is important, Marat. The creation of a first charge on the assets of the holder of a mineral concession on account of mining dues. So it is not only that the state was treated separately where the lands belong to the state, but that was given a full statutory exaction, or almost it was akin to a tax, because if your assets could be charged, you could be put on penalty, and you could, if you removed it without payment of the royalty to the state, it's a criminal offense. Now, why? The reason is, Marat, and now one realizes why the framers of the Constitution put that limitation in entry 50, while the tax on mineral rights was given to the state. A state richly endowed with minerals, oversees the task before the nation in the field of steel, non-ferrous metals, fertilizers, and chemicals. A state which has a lot of ore of a particular kind. So, Malad, this is very important. I'm sorry. So how this works?
How this works on download and how public takes it with some facts is a sense.
Union has put a very helpful affidavit, Manoj. I'm not going into that because we've divided our work. My learning friend will be showing that. And That is why this limitation was cast. Because, my lord, please consider if this is the perspective, and then you have a free running tax on mineral rights which the state can impose on royalty. It will run courts and forth through all this. It has the potential to run courts and forth.
Then Parliament can certainly legislate by saying
It has.
that these will be the limitations on the taxing power.
It has. Question is, does Parliament have to use that specific word, or is it discernible from the Act?
You're saying that the entire taxing power is excluded because this is an occupied field.
It is no. I'm sorry. The necessary implication. My lord, ultimately it will come down to, if I may say so in all humility, my lord, does Parliament need to say, and the state shall not impose any tax? Or is it clearly discernible from the provisions that this is all that a state was meant to get? It ultimately boils down to that. Because, my lord, if we accept that Parliament can say, and you shall not recover any tax, anything beyond this, is the absence of the words determinative of the matter? Or can one find from the architecture of the law, the purpose of the law, the object of the law, for mineral development, that if you leave this free, then all this mineral development, so much wasted eloquence.
So your contention there is basically that royalty is akin to it's a compulsory exaction.
Yes.
One. Two, being a compulsory exaction, it is akin to a tax or an impost. And therefore, since parliamentary legislation has provided for the quantum of the
How much you can get.
of the levy, which is in the nature of a tax or impost, therefore the state can't.
How much
that.
Parliament
That's
has
the separation.
said your fiscal exaction from this mineral, which is vested in public trust on you, is Section 9 and no more. Now, is that not a limitation which would curtail the taxing power of the state? That's the point. Or does Parliament have to add the words in Section 9 saying, and you shall not have any more tax?
Because the limitation has to be imposed by Parliament by law.
By law.
But can the law be implied? It has to be
No,
expressed.
the law is there.
It
Question
has to
is,
be expressed.
it is expressed. Section 9 says, and when I develop it, the court will see. When you say you shall recover this and not more than this, I mean, does it really mean, do you really need the words, and you shall not impose a tax on this? It can't. Your whole taxing structure, the architecture of the tax on mineral rights becomes incompatible with the law on mineral development.
Shall not recover more than this on account of this particular head, which is royalty.
Yes.
No, I'm sorry, Manoj. My point is slightly
Once
different.
royalty has been provided
agree,
for,
I agree.
the state cannot say that, well, we are going to demand anything apart from this towards royalty, because then you are governed by Section 9.
Manoj, please consider where we are. If you say in mineral development, this is the entire package. And now the law goes this far saying for the local purposes, Parliament has imposed cesses under the union legislation. And your validation law was upheld on the ground that now this taxing power is only with Parliament. If that's the statutory, if that's the constitutional landscape, what do we really mean by saying subject to a law in relation to mineral development? It doesn't say taxing power subject to a ceiling laid by Parliament. If it said subject to a ceiling laid by Parliament, one would say, show me the act. Where's the ceiling? Parliament has not imposed a ceiling, you go. I'm getting ahead of myself, but in entry 50, the words are very different. My learned friend's submission has been, show me where is this, where does it say you will not have more than this much tax? That's not what entry 50 says. If taxing mineral rights becomes incompatible with a law of mineral development, your power starts denuded. You don't need a law saying, and you will not recover tax. That is my interpretation of entry 50. Maybe right, maybe wrong.
So you're saying
That's
that
my interpretation.
if taxing mineral rights becomes incompatible
With these architecture of the law of mineral development,
the architecture stands denuded.
That's right. And, my lord, in one sense, while I think when the attorney was making his submissions, my lord, the Chief Justice spoke of the different mantras of list 2.
Yeah.
And the real answer lies there. Because, my lord, nothing, no word, no nuance of this should be ignored. Your lordships have always said we look very carefully at the entries. And these are not loosely worded entries. They are not very carefully created entries. Once I've shown this architecture, I have to develop that. So, my lord, there are broadly 3 or 4 kinds of. One is sharing mantra. Parliament will legislate on this, you will legislate on this. Public order other than deployment of centrally armed forces. So, you deal with this, Parliament will deal with that. The second is the overlap mantra, subject to law made by Parliament. So, there is a shared legislative power with supremacy in list 1. The third is other than those declared by Parliament by law. And some degree of confusion has come, if I may say so, although they are directly interrelated, of the interplay between 54 and 23, in which your lordships will see those 3 or 4 cases, and the limiting words of 50. They are very different. One is your regulatory power is denuded, but that by itself doesn't denude your taxing power. My lord, if we run a blue pencil through the words, subject to any limitations imposed by Parliament by development, the fact that the state lost the entry 23 power doesn't mean it lost the taxing power. If we are right, and this is a point to be fully developed, I'm just foreshadowing the submission, that 50 is sua generis. And it is not a limitation on your taxing power. That limitation flows from the law of mineral development, not from a legislation per se made by Parliament. And if the architecture of the law of mineral development makes it incompatible to have a tax on mineral rights, then your power stands denuded. That's the real point.
That means the taxing power is not really denuded as such.
It is eclipsed by a law for mineral development.
But the law for mineral development is not exhausted yet. There could be, it is dynamic.
Yes, of course. If tomorrow the 57 Act is repealed, your power springs back in its plenitude.
No, and also there could be various other types of provisions coming up in the interest of mineral development.
That's why again, you have to see what there is.
Yes.
Generalizations create a problem. That's why I start with the acts, the old act, the new act, the rules, the concession, and then say, how do you fit in the power to tax rates? One can't say, look at the entries and therefore your power is gone. Or look at the declaration and your power is gone.
no MMDR Act,
I'm sorry.
if there was no MMDR Act, MMRD Act and MMDR Act, and the state were to enact a legislation on royalty, that legislation on royalty would be referable to what entry?
23.
Right. Therefore,
And
once it is referable to entry 23, a
and-
legislation on royalty is referable to entry 23. Therefore, correspondingly, a central legislation on royalty is referable to entry 54.
there's no problem with
Because
that.
once we accept that a legislation on royalty by the state would be referable to entry 23, the reason why the state cannot impose royalty is because the law is referable to entry 54.
Your Lordship is great respect, absolutely right. The problem is 50 curtails a taxing power with reference to entry 54. And that's the real point of this case. It is not a taxing power versus the taxing power. Well, speaking for myself, quite frankly, the Kannadasan logic is a little hard to understand. Your Lordship will see that. So let's put that to one side, whether if in the absence of state parliament can tax. I start by saying, if state was to fix a rate of royalty, limiting, it would be 23, parliament has done it in 54. The point is, does a law of 54 eclipse your taxing rights in 50? My interpretation of 50 is yes, it does. Now, if I'm wrong, I'm wrong. But that's my interpretation of 50, and that's the real point for your Lordship to consider. That is the structure of 50.
Right. But to accept that submission, we will have to make one more hypothesis.
Yes.
That any power to tax directly impinges upon mineral development.
Yes, it does. It does. And that, Malad, there can be no doubt. Because if you say royalty impinges on mineral development, if you say a tax of 200% on royalty will clearly impinge on mineral development. Because here you will go by the substance. The direct impact and consequence of the law will be on mineral development. And that's the impact of that. I mean, that's the point for your Lordship to consider. Because we cannot be, Malad, if one may say so, we protect the state's right to recover. And Parliament has gone to the extent now, post 2015, saying auction, get all the money you can for the mineral. And over and above that, every lessee will pay to a district fund, every lessee will pay to a national fund, a cess imposed by Parliament. And all that money goes to the states. The point is leaving it to each individual state, which really means the richly endowed states, to add yet another layer of economic burden. Will clearly impinge on mineral development. Either, if Malad, royalty rates don't impinge on mineral development, then of course it is another matter. But if royalty rates impinge on mineral development, then a tax, Malad, this is like an additional tax. I'm not saying it in its legal character. I'm saying in its fiscal effect. 10% ad valorem royalty and then 30% mineral tax on ad valorem means your rate becomes 13%, not 10%. By fixing 10% is necessary for mineral development. And then allowing the state to jack it up to 13%, 15%, 17%. Will clearly impinge on mineral development. Is it forbidden or not under 50? Then another matter. That's, my lord, how it has to work. And that's why, my lord, to see what is on the ground, i.e. the law and how it works, my learned friend will show from the union's affidavit, is very necessary for your lordships to get a real picture of how 50, and then as Military said, generalizations don't help in this field. We have to see what there is. Does this obstruct this law or does this not obstruct this law? And quite frankly, my lord, why do I labor the point that it's an exaction? Because the way law has been crafted, it has been taken out of the contractual field. It has been made into a statutory impost. Why all this? To protect the revenues of the state. Because Parliament acknowledges that this is an important mineral resource, it's an important source of revenue for the state. So it must be fully protected. It's statutory. You must enforce it. You can distrain. You can prosecute to make sure you get your exaction. That's not what denuses the power. I'm sorry, my lord. It's not that is what empties it up. Our submission is that now let's look at entry 50. If this is what is there, the 57 Act in its original avatar, then modified, now as we find it, is there any space left to have a tax on mineral rights which will not trip mineral development? And that's how it has been seen. And with respect, my lord, your lordship is absolutely right. Regulating rates, Parliament has not, I put Kannadasan to one side. So that puts in one sentence, it is clear if the states cannot tax, Parliament can tax. That's the logic on which the states manage to save all their collections. But I have a separate, I deal with it separately. I call it the Kannadasan conundrum. Possibly the understanding was that if by a law on mineral development you constrain entry 23, then the limitation on 97 goes on. So Parliament can tax. It doesn't say so, but that's the only reason which can sustain that.
So, Mr. Savesh, we now go to the 1957 Act.
Yes.
And then the rules and then the judgments.
This was not necessary so that your lordship know in what context I am showing up. Now, my lord, the 57 Act, I'm going to show it in two parts, my lord, how it originally came and now how it stands, because it's undergone some serious re-engineering, if one may so use the expression, in 2015. What is the old Act? If your lordships first pick up volume 4I, page 150 onwards. This was before the 2015 amendments. Section 2. It is hereby declared that it is expedient in the public interest that Union should take under its control the regulation of mines and the development of minerals to the extent hereinafter provided. Then, my lord, the definitions are pretty much the same. Your lordships have page 150. My lord, this is okay. Page 150. My lord, same definitions. I'll just very quickly show them. Mineral lease is in C, the same thing, my lord, as the previous act. Then, my lord, minor mineral is defined, my lord. Please don't bother with the details. Section 4, my lord, is the prohibition on prospecting or mining operations in any area, except in accordance with the prospecting license or mining lease granted under the Act and the rules. So, my lord, this now cuts through private ownership. Then, my lord, Section 5 is the restriction on prospecting license. I'm not reading all this. But details are not necessary. You can come straight to Section 9. which used to earlier be in the rules, now in the statute. The holder of a mining lease granted before the commencement of the act shall, notwithstanding anything contained in any instrument of lease or any law for the time being in force, at the commencement, pay a royalty in respect of any mineral removed or consumed by him or by his agent, manager, etc., etc. That is, my lord, pre and post is in 2. The holder of a mining lease granted on or after the commencement of the act shall pay royalty in respect of any mineral removed or consumed by him or by his agent, manager, employee, contractor, or sublease from the leased area at the rate for the time being in the second schedule. Please mark one thing, Manoj. This will have some relevance when I'm dealing with the entry 50 point. Royalty is specifically, Manoj, on any mineral removed or consumed by him. And the state cannot alter this. So it has to be royalty. And it has to be on the royalty removed or consumed, or mineral removed or consumed. And subsection 3, Malad, was that the central government may by notification of the Gazette amend the second schedule so as to enhance or reduce the rate at which royalty shall be payable in respect of any mineral with effect from such date as may be specified in the notification. So completely, Malad, occupying the field as far as royalty is concerned. What its implications are, we'll deal with separately. And 9A is dead rent to be paid by a lessee. Yes, I'm sorry. Then the proviso says central government shall not enhance the rate of royalty in respect of any mineral more than once during a period of 3 years. Now, my lord, this proviso is very relevant. There is a discussion of this proviso, but it straight away, my lord, provides a response to a question which, my lord, the Chief Justice was pleased to put to me. Does this affect mineral development? Yes, it does. Even the central government's power is reined in. This will be the rate of royalty, and even you, the central government, will not revise it more than once in 3 years. And this was criticized in the discussions by some people saying, you're reining in, and they said, no, this is necessary to encourage people to develop minerals. You have to rein this in. And my lord, 9A deals with dead rent. Holder of a mining lease, whether granted before or after the commencement, shall, notwithstanding anything contained in the instrument of lease, pay to the state government every year dead rent at such rate as may be specified in the third schedule. Again, my lord, shall pay formula. And then, my lord, the rule-making power. So there's quite some discussion of this in the judgments. Section 13. Page 154, my lord, Your Lordship's compilation. The central government may, by notification in the official gazette, make rules for regulating the grant of prospecting license and mining leases in respect of minerals and for the purposes connected therewith. One or two things which are relevant. G. The terms on which and the conditions subject to which any other prospecting license or mining lease may be granted or renewed. So complete displacement. Then, my lord, over the page, I, fixing and collection of fees for prospecting licenses or mining lease, surface rent, security deposits, fines, other fees or charges, and in the time within which, the manner in which dead rent or royalty shall be payable. I'm only not showing all this to show that royalty now is an exaction. Whether it displaces the power under 23 or under 50 or not is a separate matter. But royalty is an exaction. That's very clear. Section. May I go ahead? Section 15, 14 and 15. Provisions of 5 to 13 shall not apply to quarry leases, mining leases, or mineral concession in respect of minor minerals. 15. The state government may, by notification in the official gazette, make rule for regulating the grant of quarry licenses, mining leases, or other mineral concession in respect of minor minerals, and for purposes connected therewith. And this, my lord, is virtually, this echoes 13, except that it's the state government that makes the rules. And your lordship will find here in G, 15G, the fixing and collection of rent, royalty, fees, and other charges at the time and within which the manner these shall be payable. Now, this fixing of royalty by the state is also under central legislation. And that has some bearing, as your lordship, one of your lordship's constitutional bench judgment notices, on the denudation point. Just to complete, Section 20 and 21. The provisions of this Act and rules made thereunder shall apply in relation to the renewal after the commencement of this Act of any prospecting license or mining lease granted before such commencement, as they apply in relation to the renewal of a prospecting license or mining lease granted after such commencement. And then, Malad 21. Whoever contravenes the provisions of subsection 1 of 4 shall be punishable with imprisonment which may extend to 2 years or 10,000. And that, my lord, 4, now of course it is far more clearer after a lot of amendments have been made. This is where you operate other than in accordance with the terms and conditions of a mining lease. And one of the terms and conditions is payment of royalty. Some more sections have been inserted which make it even more direct. But even initially, obviously, it loses its contractual character. That, my lord, is as far as the Act is concerned. 29, 25. Yes, I'm sorry. Yes, I should have shown that one. Section 25, page number says. Page 116. Any rent, royalty, tax, fee or other sum due to the government under this Act, or the rules made thereunder. My lord, I do not argue, let me make it clear, that merely because of this royalty becomes a tax. That's not a wrong way of reading this section. Suffice it to say, royalty is now a statutory exaction. Does it displace a tax is another matter. You have to take it step by step. But penal provisions and provisions such as 25 make it a statutory impost, if one may use a neutral word. And this impost is for mineral rights. The state, the mineral rights are granted under a central legislation by the state, not by the state under its own legislation. The state is creating these mineral rights now under a central legislation and is allowed to charge a sum of money, which is a statutory impost. I get that far. And on a first schedule, just for the record, is,
Mr. Salve, before you go to the schedule,
yes, mine.
this delegation power under 26, central
Yes.
government gives power to the state to do everything that is there under the Act.
As a delegate of the union.
That's right. So what is this thing? Are you trying to?
My lord, this is a power under entry 54, not under entry 23. It doesn't restore entry 23. There's a world of a difference between the state. My lord, the Air and Water Act say the state will. You are acting under union legislation. Your legislative power is not being restored. The union says, I will, because all these rules, the union can tomorrow correct you, withdraw you, take it away. When the state acts, it's sovereign to its limited extent. The union can't tell the state, make a rule like this, don't make a rule like that. But here, it's under the delegation of the union.
54.
So it's virtually the union granting the lease.
That's right. It is, my lord, the union saying, this is how you will create these mineral rights. And this is what you will charge for it. Does that amount to the kind of limitation 50 contemplated? Question mark. I will deal with that separately because let's not mix up all the points. But at least let me be clear as to how far I have got. And this is not all, fortunately for me, I don't need to reinvent the wheel on this. There are 3 judgments which have said this. But reading Kesaram doesn't help. That's why, in fact, I thought I should be opening a case by saying why Kesaram is wrong. Saying Kesaram is right, and of course it says what it does. These are the real points of this case. And these are the questions referred to your lordship for resolution by the referring order.
Then how to interpret entry 50 remains.
Now, my lord, I'm sorry. There's a lot of what your lordships are hearing is nothing new. The late Mr. Nariman had said all this when we argued India cement, the privilege of being with him. But it didn't get captured in the judgment, that's all. And my lord, finally, there was one point made just to deal with it. Section 29. So then my learned friend said section 25 was only if there's something which continued. Even the old rules don't continue in full. All rules made or purporting to have been made under the Mine and Minerals Regulation and Development Act 1948, 53 or 48 shall, so far as they relate to matters for which provision is made in this act, are not inconsistent, be deemed to have been made under this act as if this act had been in force on that date on which such rules were made, and shall continue in force until they were superseded by any rules under the act. So, this is the usual adapting provision, saying rules will continue to the extent consistent with the act. And then, 30 is the power of revision. And that's important. Because the union, my lords are pleased to ask me, is the state acting on its own? No, because the union, see the power of revision, my lord, which the central government may of its own motion or an application made within a prescribed time by any party, revise any order made by the state government or authority. For major minerals, it's complete blanket power of the union.
The second schedule gives us the royalties now.
Yes, and that's only my lord has to show that. Schedule gives the royalties. Some are, my lord, for example, for precious, semi-precious stone, it was ad valorem. Sale price at the pit's mouth, some was per ton. Sometimes a lot of these simple expressions become so complicated with technology. Pit's mouth is easy to understand. But when you produce gas, what is the price? Wellhead price. That which is 2 kilometers under a kilometer of water, or that which is at the flange point after the gas is clean. Now, my lord, this is, as far as this is concerned, the act as it was. Please see Mineral Concession Rules 1960, and then I'll show some of the amended provisions of the act. The regulation India. Left the name.
Session goes from your book.
I don't know. Where you are.
Same volume, 4I.
Volume 4I, mother. My lord, very quickly, if I may, show material parts. My lord. The certificate of approval got jettisoned. And my lord, chapter 3 again divided between land in which minerals vest in the government and even whether minerals vest in the state government, all the grants are under the union legislation. All the steps are under union legislation and union rules, because the MC rules were made by the central government. I'll just give the numbers, go it quickly. Rule 9, 10, 11, 12. Say how it is to be granted. Again, a statutory mechanism, or the details are not of any importance. 14 is the conditions of a prospecting license. And your lordship will just see that again. Page 237, every prospecting license granted shall, in addition to any other condition that may be specified, subject to the following conditions, namely: 1, the licensee shall pay such prospecting fee as may be fixed by the state government, being not less than 50 paisa and not more than 5 rupees per hectare of land covered. Then, my lord, we have under chapter 4, unless there's anything specific your lordship want me to read, I'm just skipping through. Chapter 4 begins page 239. Application for grant of mining lease, which vest in the government, shall be made to the state government in Form 1 through such officer or authority as the state government may specify. So that action of the state government is of specifying an authority also is under the union rules. Then sub-rule 4 says once the government receives an application and has decided to grant an area to an applicant, it must communicate the precise area to the applicant, then what the mining plan must have. And if we move on, my lord, Rule 24 is disposal of application for mining lease. This is, my lord, where the orders were passed. Now, it's interesting to see Rule 26, page 242. The state government, after giving an opportunity of being heard, and may, for reasons to be recorded in writing, communicated to the applicant, refuse to grant or renew a mining lease for a whole or part of the area. The whole understanding, these are minerals vested in the state, they have to be developed, we need private capital to come in. It's all becoming extremely tightly controlled by union law and union rules. Then, my lord, conditions under Rule 27. Similarly, my lord, 27(1)(c) is dead rent, 27(1)(d) is surface area, surface rent, and please mark, my lord, it says water rate in D. So the water rate is imposed here. Now, what is interesting is, my lord, 27(5). Which page is it? 242. If the lessee makes any default in the payment of royalty as required under Section 9 or the payment of dead rent as required under 9A, or commits a breach of any of the conditions in 1, 2, and 3, except the condition referred to in F of 1, the state government shall give notice to the lessee requiring him to pay the royalty or dead rent and remedy the breach within 60 days. And if the royalty dead rent is not paid in the breach not remedied, the state government may, without prejudice to other proceedings that may be taken, determine the lease, forfeit the amount of security deposit. So even this is not under central rules. So the entire operation of mineral rights, the creation, the administration, the terms and conditions, and its determination. Minerals vest in the state, the mineral development is entirely under the union. And again, my lord, Rule 31, because this, my lord, puts us onto the form.
Yes.
Then my lord, Rule 31, where on an application for the grant of a mineral lease, an order has been made for the grant of such a lease, a lease deed in Form K or in a form as near thereto in circumstances may require be executed within 6 months. So this is now, my lord, a statutory form. It sets out how the lease is to be granted. Here again, my lord, there is a separate chapter 5. Which page is that? Page 247, which deals with minerals which vest in a person other than the government. I won't trouble your lordship with the details. It has the same thing, including no premium, conditions of mining lease, etc. But for the state, the mining lease has to be in Form K. And finally, my lord, in chapter 7 is revision. Any person aggrieved by any order made any person aggrieved by any order made by the state government or the authority in exercise of the powers conferred on it by the act or rule may within 3 months from the date of the communication apply to the central government triplicate for revision, etc. It's a complete control by the union. Rule 72. Now, my lord, there's an important point to note, page 251, because this will have some bearing, my lord, when I deal with the entry 49, entry 50 point. The holder of a prospecting license.
Which provision?
I'm so sorry, my lord, Rule 72.
72.
The holder of a prospecting license or mining lease shall be liable to pay to the occupier of the surface of the land over which he holds the prospecting license, or as the case may be the mining lease, such annual compensation as may be determined by an officer appointed by the state government by notification on this behalf, in the manner provided in Rules 2 to 4. So, my lord, the distinction is made between the mineral rights and the surface of the land. This will have some bearing on, my lord, whether you can say I'm taxing the surface rights, and the measure of that is the value of the mineral rights. Which is the Murthy logic.
Entry 49.
Entry 49, it's a tax on surface rights, but the measure is the royalty. So this is one, but the Form K begins at page 264. One or two important things, my lord, in this. I want to show this because it's important. It speaks of royalties to be paid, no question about it. And that's at in part 5, page 267. And surface rent and water rate. But the details are not relevant. I'm very quickly just showing the provisions. And part 7, covenants of the lessee, is interesting. The lessee shall pay rents, water rate, and royalties reserved at such times as may be provided, and also pay and discharge all taxes, rates, assessments, impositions, whatsoever being in the nature of public demands, which from time to time shall be charged, assessed, or imposed by the authority of the central government upon or in respect of the premises and works except demands for land revenues. So, my lord, this is important. This contemplates public demands which shall from time to time be assessed or imposed by the authority of the central government, not by the central government. That means the power flows from the central government. Whoever may be the, whether it's done by state, an officer of the state, or done by an officer of the center. That's it. That one, unless there's anything else I can show the lordship. But that's as far as is relevant for the present. Yes. Oh, my lord, like the previous renewal. Similar, I didn't, my lord, read it because it's pretty much the same as the 48. Now we may not come to the new act as it now stands. My lord, this should again be in volume 4, begins at page 910. Go back.
water rate. What is that water rate?
Malad, I
I'm
have tried
thinking
to
about
check.
something. I do not know
I
whether
will
that.
try and answer the question tomorrow, Malad, because these are
No,
such old,
No, correct. Because
could be under local laws.
it may have nothing to do with the law, but when Jamshedji, the original Jamshedji, he wanted to set up steel plant. So for steel, you need iron ore.
Yes.
I am remembering what is written by R.M. Lala in Beyond the Last Blue Mountain, the
Yes.
book.
Yes. Yes.
So there, he brought, I think, the expert from Paris, perhaps, one who was identified as a world expert. He brought him, and they were traveling on elephant back to find out where the rich iron ore could be available. And eventually they found a mountain of iron ore
Yes.
where I think the percentage is about 60%, which is very high. But then they realized that there's no water, because water is essential in order to extract the ore.
Yes.
And then they said that it's not going to work out. But suddenly, just after some steps on bullock carts and elephants, they suddenly found a vision of 2 rivers or 3 rivers converging and a huge water body. And that is where I think the Jamshedpur, the current Jamshedpur is located.
Yes.
I think that's this water thing is a very relevant
It's
thing
very,
for mind.
in fact, if one goes, I didn't want to enter that, my learned friend is going to be
So
showing.
we are trying to distract you a little.
No, Malad, my learned friend is going to show that part. Mineral development today is a very highly complex. In fact, one of the problems today which people criticize is because of all this which we have created. India has 17% or 18% of the world's mineral resources, and we import iron ore. We import coal. And that is why, Malad, we are now taking a very firm position, even with the COP, that why should we give up our coal resources? The Western world has finished off all their coal resources and now lecturing us, saying don't use fossil fuel after they've exhausted their fossil fuel. We still have our fossil fuel lying very much in the bowels of the earth.
The Chief Justice was mentioning generational equity,
That's right.
intergenerational.
And that has now come in, Malad. In fact, so many of these concepts, that's the act which I'm going to show now, have come in. And how tight the scheme has become. And now we have acknowledged, Malad, we flirted with the idea of saying this must all be reserved. There was a time, Malad, we used to all challenge reservation by states. For public sector, reservation by this, reservation by that. All that led to is a decline in the production. Even coal mines, Malad, now gradually we are seeing the production of coal going back into private hands because the technology, the capital investment, and the efficiency is far greater in a resource where you allow the private to come in and control them rather than do it yourself. So these are all changing ideas. And the idea now of the act, which somewhere along the way, I mean, as they say, what's in a name, but somewhere along the way, the Regulation and Development Act became the Development and Regulation. It only shows the increasing concern over development. Earlier concerns were about reining in private exploitation. Now it is more about developing our resources which are held for the benefit of the people. So there's a shift in ideology. And I'll show Malad the National Mineral Policy of 2019 when I close this part of the session. The new act, Malad, if your lordship sees, and the act is now stands. Declaration is the same, Malad. So I won't read it. Please notice some definitions added. AA, 3AA.
Is the act here in the short form?
It's there. I'm saying, page 921 onwards, volume 4. But I'm using the book because in the I'll be able to give your lordship pages, but I found it very difficult because somebody has copied from SCC online. And that in between has commentaries, judgments, and then the next section, you don't know where the commentary ends and where the section begins.
Yes.
3AA. Dispatch means removal of minerals or mineral products from the leased area and includes the consumption of minerals and mineral products within the leased area. The other definitions are not pretty much the same, so I won't trouble your lordship reading them. 4 is the same. And what is interesting, my lord, to note, apropos the question which your lordship was, the comment which my lord made, 4B. Notwithstanding anything contained in 4A, the central government may, in the interest of maintaining sustained production of minerals for the country, prescribe such conditions as may be necessary for the commencement, continuation of production by the holders of mining leases who have acquired rights, approvals, clearances, and the like under 8B. Page 936, Malad. I'm sorry, I should have done the page now. Malad, today, the old notion of sovereign, etc., is all today it's all seen as a partnership. So if you're given the mineral, it's not for your private humor. You have to sustain production, and if you don't, the government can make rules. If you're not keeping up the pace of production, get out. Somebody else will come in and do a better job. In fact, my lord, yes, I'm grateful to my friend. One of the conditions added in the old termination provisions, in fact, please see 4A, my lord, it's very important. Where the central government, after consultation of the state, is of the opinion it is expedient in the interest of regulation of mines and mineral development, preservation of natural environment, control of floods, prevention of pollution, or to avert danger to public health or communications, or to ensure safety of buildings, monument, or other structures, etc., etc. Request the state government to make a premature termination of a prospecting license. This one. So, Malad, this is the first, and a lot of changes have been made, Malad. I remember one of the things we struggled here in the forest matter was to get the Karnataka mines closed, state mines, which were creating pollution. Now it's become statutory. And subsection 4 of this is the mirror image of, is the other side of the picture, where the holder of a mining lease fails to undertake production and dispatch for a period of 2 years after the execution of the lease, or having commenced production and dispatch, has discontinued the same for a period of 2 years, the lease shall lapse on the expiry from the date of execution, and maybe the discontinuance of production and dispatch. And then we have 4B, which is efficiency. So today, Malad, it's more, you are really working a concession, not just for your private gains, but as a part of the overall mechanics of mineral development. Then, Malad, the periods for which such leases may be granted is statutorily controlled under sections 7 and 8. I won't trouble your lordship with the details. And then we have section 9. This is at page 942. The holder of a mining lease, 9(1) is the past, not commencement of the act, notwithstanding anything contained in the instrument of lease or in the law in force, etc. A royalty at the rate for the time being specified in the second schedule. And subsection 2 is at current times. Holder of a mining lease granted after the commencement shall pay royalty in respect of any mineral removed or consumed by him, by his agent, etc., in the leased area. If your lordship see this now and go back to section 4(1)(a).
Page should that
Yes,
be, the PDF page?
4(1)(a). 924. No person shall transport or store or cause to be transported or store any mineral otherwise than in accordance with the provision. So 4(1) is the same. No person will undertake reconnaissance, prospect or mining operations in accordance with the terms and reconnaissance, etc. And now transportation expressly is brought in. And if your lordship see section 9(2), it says royalty on mineral removed or consumed. So if you are transporting it without paying the royalty on mineral, you're violating 4. And if you're violating 4, it's a criminal offense. That is one important dimension of the matter. Then, my lord, two other new provisions which your lordship must see are 9(b) and 9(c). How, my lord, these operate are there in the affidavit of the union, but my lord, the learned solicitor will be showing those. We don't want to duplicate work, so I'll just show the provision and the legal implications. So this is what the states used to always say, that people take the mineral away and we are left with the baby. We are the ones who have to deal with the areas. So 9(b) is very important. In any district affected by mining related operations, the state government shall by notification establish a trust as a non-profit body to be called the District Mineral Foundation. This came in 2015. I may just anecdotally take 5 minutes, 2 minutes distraction here. This was first done by your lordships in the Vedanta case, when granting environmental claims. Your lordship said, for that area, you will set up a trust headed by the chief secretary. The people from the company will be there. Of the top line, you will contribute a percentage, and that will be used for development of that area, the Lanjavar mining. The government, despite which, didn't grant the lease, but that was another story. But that was first brought here. Two important things have been brought by lordships, and it might, I don't know whether your lordships have ever seen the details. The NPV judgment, the net present value judgment, on how and it started with mining, because when you start diverting forest land for non-forest purposes, it's not enough that you pay for the tree or you pay for the land. You have to pay the net present value of the loss to ecology. And there are now complex mathematical models on how that is to be calculated. Your lordship's judgment on that one. That's the intergenerational equity, how your lordship started, and now, of course, the statute has picked up. And now 9B is ruled. Now here again, it's under union legislation. This is under union legislation, so the state does it under union law. And then, my lord, the rate is at subsection 5 of 9B. The holder of a mining lease or a composite license granted on or after the date of the commencement of the Act 2015, other than those covered by subsection 2 of 10A shall, I'm so sorry, in addition to the royalty, pay to the district mineral foundation of the district in which the mining operations are carried out, an amount equal to such percentage of the royalty as is paid in terms of the second schedule, not exceeding 1/3 of the royalty as may be prescribed by the central government. Well, this is exactly what the taxes are doing. So this is not an impost by the state. It's an impost by the union. I'm a little bit using a colorless word, but not impost. You call it a tax, a fee, or something in between. And this is exactly what number of the laws under challenge purport to do. The holder of mining lease granted before or after the commencement of the Act shall, in addition to the royalty, pay to the district mineral foundation in which the mining operations are carried on, an amount not exceeding the royalty paid in terms of the second schedule, in the manner and subject to category. So, it's royalty and an amount not equal. So, the same thing all over again. You have to pay. Not this. There's a small thing which your lordship directed by way of NPV. I don't know what the figure stands now, but last when I was assisting your lordships 8 years ago, 9 years ago, I think it had hit about 40,000 crores, 50,000 crores. The interest on which was enough to do so much for the states. And I do remember, we got a request from the people in Assam, the forest rangers saying, can we have some money from this? So an application was brought by the CEC, that Centrally Empowered Committee. The Micas, I used to move those applications. And what did they want? They wanted 8 lakhs or 10 lakhs. They said, we want to buy 2 gypsies. So, and 2 or 3 guns so that we can chase the poachers. And that little amount made so much difference in containing poaching. So, these funds are properly utilized. There's so much which can be done, and these are large amounts of money. Well, learning friend will give the exact figures. These are large amounts of money. And there is another amount under 9C. The central government shall, by notification, establish a trust as a non-profit autonomous body to be called the National Mineral Exploration Trust. This is not for doing exploration work, and in subsection 4 of 9C, the holder of a mining lease or a composite license shall pay to the trust 2% of the royalty in terms of the second schedule. Please mark how it is done, 2% of the royalty.
But these have all come in 2015.
Yes.
But we are considering the acts prior to them.
No, of course. But my submission is going to be even before these sections were put in, what was the connotation of mineral development? These sections are these are all mineral development sections. So if that power was taken away, it was for the union to do it. The union waited till 2015 to do it, but they've done it. But if the power was not available, if the limitation came in, it came in by the overall act. And realizing that that limitation is taking away the power of the state to raise resources, the union is now filled in the gap. I'll not deal with this more fully, but just to show, this is now the new structure. This is one. Second very important change which has come is section 10B. Which? 948. Because now the state cannot grant mining lease by an order, etc. It has now all to go by auction. But I'm deliberately not reading 10A. There are a lot of cases pending on 10A. There are some construction issues. Anything said by 9 judges, my lord, will, even by in passing, will affect those. 10B is what we are concerned. The provisions of the section shall not apply to cases falling under 17A. Then minerals specified in part A of the first, which is, my lord, coal and lignite. That's only the two fuel minerals. Minerals specified in part B of the first schedule, your lordship may be pleased to note that this is only the atomic minerals. Other than that, everything is covered. And then land in respect to which minerals do not vest in the government. So that is still maintained. Now, where the government land is concerned, see now the qualitative change which has come. First, my lord, the state has to notify the areas for grant of lease. That's in subsection 3. In areas where the existence of mineral content of any notified mineral is established in the manner prescribed by the central government, the state government shall notify the area for grant of mining lease for such notified mineral in terms and conditions subject to which mining leases shall be granted, and any other relevant conditions as may be prescribed by the central government. So this continues now, as may be prescribed by the central government. The provisos are not relevant for us for the present. Subsection 4. For the purpose of granting a mining lease in respect of any notified mineral in the notified area, state government shall select through auction by a method of competitive bidding, including e-auction, an applicant who fulfills, and then the criteria is given. What is important is 5. The central government shall prescribe the terms and conditions and the procedure, subject to which the auction will be conducted, including the bidding parameters. So everything which the state does is as per prescribed by the center and under the authority of the center. And any mineral rights now are created by this process. But just for the record, 11A is mineral rights for coal and lignite. We don't need to see the details. Section 13. Page 958. Read with the definition of mineral concession. So, a definition is now inserted. Okay, 2A, 3A. Section 3. Sorry, 922. 3AE is the definition of mineral concession. which means either reconnaissance permit, prospecting license, mining lease, composite license. So now, my lord, we have this umbrella expression, mineral concession. In section 13, it says the central government may by notification in the official gazette make rules for regulating the grant of mineral concession. Earlier, my lord, we had this reconnaissance permit, prospecting license, mining lease. They have now coined this expression mineral concession, an umbrella expression, and said mineral concession in respect to minerals and the purposes connected therewith. In my lord 13, just see one or two things, my lord. Your lordships don't mind. In subsection 2, F, the procedure for obtaining a mineral concession in respect of any land in which the minerals vest in a person other than the government, and the terms on which, the conditions subject to which a permanent license or lease may be granted or renewed. So now, my lord, this is made much more stricter. And my lord, I, just below that, fixing and collection of fees for mineral concession, surface rent, security deposit, fines or other fees or charges, and the time within which and the manner in which dead rent or royalty shall be payable. Even that is now done by the central government by rules. And just for completeness,
The state executes the lease deed. Is there any other form under the 1957 Act where a private person can execute?
K. No,
Form
form is
K.
the same. Form is the same. K. Because even the 57 Act, the only thing is the royalty goes to a private person.
Private person.
Otherwise, everything is controlled completely.
Because under that, the rents and royalties are reserved under the lease deed.
Yes.
But there are no other reservations made under that,
No.
such as this, what you said, 9B and 9C, where a percentage of the royalty has to be paid. They are not reserved under the lease deed.
I'll just check that one. 1 minute, please.
Incorporated.
But what is important is the ground reality is the major minerals. I don't think there are